Very good evening, dear friends. It's a great pleasure. Welcome to the third semester session of LL.M. Now you are in final year, and then congratulations to everyone, and I wish you all the best for your future pursuits. So we will go on with this program on law of banking and negotiable instruments, LL.M. second year, for third semester, of course, now it is, and then the subject is Law of Banking and Negotiable Instruments Act. Friends, this particular subject consists of two parts. One is the law of banking, and the other one is the law of negotiable instruments. In fact, some of the books I have already suggested, I again repeat that for banking, the standard textbook is Tannen's Banking Law and Practice in India. Latest you can get. And of course, there is another book in the examination point of view, good book. It is P.N. Varshney, Banking Law and Practice. Sultan Chand and Sons publication. Tannen's is Orient Law House. Then the third one is the Negotiable Instruments Act by Avtar Singh, Eastern Book Company, Lucknow. Then for reference, another important book, Bhashyam and Adigas, Negotiable Instruments Act, Bharat Law House. These are all the important textbooks. Of course, there are a number of other books. In fact, it is up to you to study, but these are all the more prominent textbooks which you can rely upon and then study in the examination point of view as well as gaining knowledge. So, with this background, we start off our discussion on the banking law, wherein this is a very wider subject, and then banking law, in fact, is a concept derived from Britain, and then the system of banking actually was evolved as back as 2000 BC, before Christ. Then, friends, in ancient India also, the banking system was practiced, even though it is not in that kind of format we are following now in India. And then the concept of banking was given sanctity of law when it has become the central point of trade, commerce and business, domestic as well as international, and several legislations were brought in, changes were brought in by the governments of various countries in the world to regulate the banking business. So, the definition and meaning naturally will have to be discussed before we start off, and how this particular banking business was developed in the world communities in general, and particularly in India also must be examined, which we are going to do that exercise in today partly and in future classes. And then different governments evolved law governing the banking business, originated in UK and spread to other parts of the world. Here, this is a subject which has to be taken on the international arena. That is the most important aspect in law of banking. Then, friends, actually, I told you, banking evolution goes back to 2000 BC. 2000 BC. Historically, it went back to 2000 BC. Then, the regulator of banking business in India happens to be the Reserve Bank of India. And the dispute resolution fora of course, happens to be multifold, and high courts, Supreme Courts, the Debt Recovery Tribunal, then the Securitization Act, its mechanism, and so on and so forth. It is the Debt Recovery Tribunal which is this dispute resolution forum, but regulator happens to be Reserve Bank of India. As I told you in my earlier sessions on company law, the regulator of company law in India is Ministry of Corporate Affairs. Dispute resolution, National Company Law Tribunal. In the same way, IBC, the regulator is the IBBI, Board. Dispute resolution, National Company Law Tribunal. In the same way, corporate securities. The regulator is SEBI. Dispute resolution is the SAT, Securities Appellate Tribunal. Then onwards, naturally. In the same way, here also, basically, the regulator as an institution is the Reserve Bank of India. Of course, Reserve Bank of India is the basic regulator, and ministry has a different role to play thereon. Then, friends, we find the history of bank in the world. Actually, you see that it's very interesting. Originally, it started with, in the world community, to design a system to borrow money for business purposes, and further also wanted to people deposit money and valuables for safe custody with trustworthy people. Then, for reaching that goal, the system of banking was evolved. So, the derivative happens to be the word bank was derived from the French word bankers and also banker, bankers, banker, which means bench. The meaning of bench is transactions of business in the marketplace on a bench. This evolved as a practice originated in Italy by the famous Jewish money changers. Then another school of thought was also evolved that the word bank was derived from the German word called back, B-A-C-K, back. The meaning is a joint stock fund. So, friends, banking operations revolved around the transactions of depositing money, depositing various valuable things, then borrowing loans, of course, on interest. Basically, there are various functions of banking, but fundamental functions happen to be depositing money and valuables and borrowing loans on interest. That's all. Of course, there are different definitions given by jurists, courts, and statutes. Statutes, the legislative made law, judge made law, but commonly all the definitions are based on the basic functions of depositing money and valuables and borrowing loans on interest. So, in the modern times, the definition of banking was more expanded to multifarious transactions conducted by the banking institutions under various laws related to the banking business operations. What are those laws? The Reserve Bank of India Act, Securitization Act, the DRT, debts, recovery of debts due to the Banks Act, surfacing, Bankers Books Evidence Act, Negotiable Instruments Act. Without NI, there is no banking. So, taking all these issues into account, the banking business started off at a domestic level, expanded to international level, and without banking today there is no world trade, commerce and industry. So that is the way the banking system was developed. So friends, on the development of banking concept, I take you back to Babylonians, who stated rather by the jurists that they have developed the banking system in 2000 BC. Then the practice in those days was the people used to deposit their money and various valuable things with the temples. Then the Romans and the Mohammedans prohibited charging of interest on money borrowings, treating it as a sin in fact. Several religious scriptures also advocate this particular concept. Then in India, the banking system was developed in the form of depositing of money and also pledge of valuables. Even in the Smriti period, that is the most important historical, chain. And in the Vedic period also it was referred to, but may not be in the form as today, definitely, but in a different way we can get the link of that. The Manusmriti contains a chapter on deposits, pledges, interest on loans. Then Kautilya's Arthashastra also contains details on interest on this particular loans. Every one of you must read Kautilya's Arthashastra. You don't know Sanskrit, even I don't know. What we had to do? Go to internet and get the translation of Kautilya's Arthashastra made by the great mathematician Mamidola Venkataramanaya. In fact, there is a trust of him in Maredpalli area of Secunderabad. So, by going through that, your mental horizon will be expanded. And you will understand, at his time, a civil administration of justice, criminal administration of justice, how they were dealt with, the fora, and then the enactments. What were the laws that were made in order to ensure public welfare, where banking was one of the issues with regard to charging interest on loans. So I request all of you to go through this book, purchase or get it somehow. So the banking system was evolved as a necessary commercial practice, and subsequently, as you know, it is a practice which becomes law, not law becomes practice. Law cannot be imagined. Practices cannot be imagined and put into law. Only the law will become, the practices will become the law, and that will give further thoughts to improve and go further or make further laws. So at this stage, in India, the banking system was regulated with appropriate legislative sanction. Every country has done it. Then the British government in India for the first time brought the legislations to regulate the banking business. And then the Indian banking law was originally based on English law. And subsequently, there are several changes brought in the Indian banking system in tune with the changing economic conditions, social conditions, political conditions, and such things in India. And so, appropriate changes were brought or being brought to cater to needs of the changed society. So, friends, the particular legislative background now in the present form is with the British. Originally it was in the Smriti period, Vedic period in India, with Manusmriti also. Then Kautilya's Arthashastra also. This is the historical data. Whereas legislative history is concerned, history of banking as such, go to Kautilya, Smriti, Vedic period. If it is legislative history, then it is a matter pertaining to only British, where they introduced it and then they have made several laws thereon. Now, friends, with this background, I conclude the today's lecture on the evolution of banking system and the origin of it, the derivative. And friends, in next session, I will deal with the definition and meaning of banking.